Welcome to the third lecture of the Human Rights Lecture Series. The topic for this lecture is WASH and human rights. During this lecture, I will explain the interlinkages between WASH and human rights, how access to drinking water and sanitation became recognized in human rights law, and what this means in practice for rights holders, but also for WASH practitioners. So first of all, what is WASH? WASH is a collective term for water, sanitation, and hygiene. Because of the interdependent nature of these three issues, they are grouped together. For example, without toilets, water sources become contaminated, and without clean water, basic hygiene practices are not possible. At the same time, access to safe drinking water and sanitation are human rights that billions of people still do not enjoy. According to the World Health Organization and UNICEF, 785 million people lack basic drinking water service, and over half of the global population lack safely managed sanitation services. Safe and readily available water is important for public health, poverty reduction, education, and food security, among others. This shows the interrelation between and interdependence of the rights to water and sanitation and other human rights. For example, contaminated water and poor sanitation are linked to transmission of diseases such as cholera, diarrhea, hepatitis A, typhoid, or polio. It is estimated by WHO that 829,000 people die each year from diarrhea as a result of unsafe drinking water, sanitation, and hand hygiene. With these issues in mind, let us look at the key instruments on the human rights to water and sanitation to better understand what these rights mean in practice. We have seen in the first lecture that human rights can be found in different international but also regional instruments, and that treaty bodies play an important role in their interpretation. For the human rights to water and sanitation, an important milestone was General Comment No. 15. It was adopted by the Committee on Economic, Social, and Cultural Rights in 2002. The committee determined that the right to water is implicitly included in the right to an adequate standard of living found in Article 11 of the Covenant on Economic, Social, and Cultural Rights, and that it is related to the right to health, as in Article 12 of the same treaty. The general comment further clarifies the normative content of the right to water, which we'll unpack later in this lecture. Further recognition of this right came in 2010. The United Nations General Assembly adopted Resolution 64-292, which recognized the right to safe and clean drinking water and sanitation as a human right that is essential for the full enjoyment of life and all human rights. The resolution called for international efforts to help countries provide safe, clean, accessible, and affordable drinking water and sanitation for all. Shortly after, the Human Rights Council unanimously reaffirmed this position with Resolution 15.9. In December 2015, the human right to sanitation was explicitly recognized as a distinct right by the UN General Assembly in Resolution 70-169. The General Assembly recalled that the rights to water and sanitation have distinct features which need to be treated separately to address specific challenges in their implementation. It also stated that sanitation remains often neglected if it is not addressed as a separate human right. The same year, the 2030 Agenda for Sustainable Development was adopted. It contains a standalone goal, number 6, on ensuring the availability and sustainable management of water and sanitation for all. Goal 6 includes important dimensions related to the human rights to safe drinking water and sanitation. In addition to soft law, these rights are via interpretation included in provisions of several international human rights treaties. At the same time, we have to keep in mind that certain aspects of these rights are also found in other treaties. We can think of the conventions of the International Labour Organization, or within regional frameworks, in particular in the Inter-American and the African human rights systems. Now, what does it mean to enjoy our human rights to water and sanitation? The human right to water means that everyone is entitled to sufficient, safe, acceptable, physically accessible, and affordable water for personal and domestic uses. As for the right to sanitation, it entitles everyone without discrimination to have physical and affordable access to sanitation in all spheres of life that is safe, hygienic, secure, socially and culturally acceptable, and that provides privacy and ensures dignity. Each of these elements that are emphasized in the definitions can be categorized in 5 so-called aspects or criteria: availability, accessibility, acceptability, affordability, and quality. In addition to these criteria, human rights principles of non-discrimination and equality, access to information, participation, sustainability, and accountability have to be respected and protected in order for the rights to be fully realized. Let me first address the 5 criteria before coming back to the principles in the context of the rights to water and sanitation. The 5 aspects or criteria of the rights to water and sanitation are fundamental for the realization of these rights. If I have access to drinking water at an affordable price, but this water is not of adequate quality and the source is reachable only after a long, dangerous walk where my physical safety is at risk, then my right to water is not fully realized. The criteria of quality and physical accessibility would not be entirely met due to the distance to the source and the lack of safety in accessing it. It is therefore important to keep in mind all these 5 criteria because ultimately all 5 are needed for the rights to water and sanitation to be met. Accessibility, for example, means that everyone has the right to a water and sanitation service that is physically accessible within or in the immediate vicinity of the household, educational institution, workplace, or health institution. There is thus an element of distance and time, but also of safety and design, as the user needs to reach the facility safely, and the design must permit it to be used by everyone. The different criteria overlap and are interdependent. For example, we can put the distance element either under the accessibility or under the availability criterion. What is important is that we ensure that the distance is within safe reach for everyone. The Committee on Economic, Social, and Cultural Rights refers to the World Health Organization to quantify accessibility. According to the WHO, a water source has to be within 1,000 meters of the home and collection time should not exceed 30 minutes. This reference is often applied to evaluate whether access to water and sanitation is sufficient. From a human rights perspective, it is important to remember that some people require more water or are not able to physically reach a sanitation facility, even if it is within 1 kilometer. These references should therefore not be seen as fixed values to know if a right is realized or not. A person with certain health issues might require more water than someone else to clean wounds or bedding more regularly. Cultural and social preferences must also be taken into account in service delivery to ensure the acceptability of water and sanitation services. That can be deciding on the use of seated toilets instead of squat toilets, the positioning of the facilities, the preferred materials for menstrual practices, or the acceptability of the color of the water provided. In light of these criteria, if we talk of wash issues, one can be more specific. What is exactly the wash issue at stake? Is it affordability or acceptability? Is it a design problem with the sanitation facility for people with disabilities? With these criteria or aspects, we can better analyze and address the problem in terms of the human rights to water and sanitation. In addition to these criteria, the human rights framework offers us certain procedural guarantees or principles that are necessary for the realization of the rights to water and sanitation. The principles and procedures apply in a cross-cutting manner so that the rights are realized in their entirety. For example, people must be able to participate in all processes related to their access to water and sanitation. It is key to ensuring that the decisions taken respond to the actual needs of the people. Without it, it is possible that their access to water and sanitation would not be suitable to them. People also need to have access to information. This means, for example, being informed about the costs of the service or be aware that the connection will be temporarily cut due to a contamination. Without such procedural guarantees, the rights for these people would be more difficult to realize. Sustainability is another principle that is essential for the human rights to water and sanitation. The services and facilities that have been improved must be maintained and retrogression avoided. But sustainability is more than reliability. The services must be available for present and future generations and not compromise the ability of future generations to realize the human rights to water and sanitation. To do so, water and sanitation must be provided in a way that respects the natural environment and ensures a balance between the different dimensions of economic, social, and environmental sustainability. With this overview on key human rights principles in mind, let us have a look at this video from Kenya that demonstrates how through the Watershed program on empowering citizens, people, including disadvantaged groups, such as people with disabilities, are more informed and involved in water resources management. We see in this video how citizens themselves and CSOs can play a crucial role in the realization of the human rights to water and sanitation.
We could discuss what really
when the community plan for the budgets, not unless we have one of our own there, nobody talks about us. Or they'll give us a project which we didn't really need it. But if we have a reader like me, I'll go to the county, tell them our problems, they will listen, and maybe they will look for a solution next time. So when we go to the meetings, we talk about water, how it affects women with disability.
When it comes to decision making, persons with disabilities, we are usually left behind.
It's a very big step ahead because they have learned to accept us. Before we used to be as if we are a bother to them. But now they understand that we are people who are friendly, people who can associate, people who can reason like them.
Let us now look at which obligations states have towards improving the national framework, or how CSOs can advocate for such changes. The action of the state, the duty bearer under human rights law, can be demonstrated, among others, in its adoption of laws, regulations, or implementations of strategies. In practice, different norms and principles related to the human rights to water and sanitation can be found in different national instruments. For example, the right to water can be included in the constitution of a country, and the law can further articulate an aspect of one of the criteria we saw earlier. With affordability, for example, a law could require that procedures for the discontinuation of water services must not result in a person being denied access in case of inability to pay. A regulation or a policy could supplement this type of obligation by specifying how this will be implemented in practice. That could be a specific tariff system or a subsidy, for example. Examples can also be found in other instruments. Building codes can require that a certain amount of toilets for men or women are built in schools or public places. These are only examples, but ultimately, the national framework should articulate these different aspects of the 5 criteria and principles of the human rights to water and sanitation to make these rights, as understood at international level, become a reality. Monitoring the realization of these rights at national level is essential for accountability, one of the principles I mentioned earlier. In the suggested reading, you will find monitoring tools tailored specifically to the human rights to water and sanitation. National human rights institutions, commonly referred to as NHRIs, can play an important monitoring role as well. In this interview with Ms. Ruth Sekindi, Director of Monitoring and Inspections at the Uganda Human Rights Commission, we hear more about the protection, promotion, and monitoring role of NHRIs, and how the Ugandan Commission has been working on the human rights to water and sanitation at national level.
My name is Ruth Sekindi, a lawyer by profession and an advocate of the High Court of Uganda. I have a few questions that I'm going to respond to. And one of it is that knowing the human rights institutions have an important protection and monitoring role with respect to human rights. I'm required to tell you about how the Uganda Human Rights Commission has been using the International Human Rights Framework to work on the human rights to water and sanitation at the national level. Now, Uganda has ratified a number of international instruments that relates to water, and one of them is the International Covenant on Economic, Social and Cultural Rights that provides for the right to an adequate standard of living. Now, when you break it down and you look at General Comment number 15, it talks about the right to water as one of the determinants of the right to an adequate standard of living. Uganda has also ratified the CEDAW, the Convention on Elimination of All Forms of Discrimination Against Women, and it also provides for access to water for women, and also the CRC, the Convention of the Rights of the Child, and it also provides for issues of water. Now, when we look at access to water at the international level and the instruments that we as a country have ratified, we realize that we have domesticated those instruments into our Water Act and water policy, national water policy as a country. Now, these instruments are very critical in ensuring and guiding the states to in realizing access to safe water in good amounts for everyone. Now, when we look at the Sustainable Development Goal number 6, it also provides for access to water for every person without any form of discrimination. And that is very important because then when we look at the international laws, it relates or it can be transferred to national laws and policies. And that is why ratification of these instruments can lead to domestication, and also it leads to access to safe and adequate water for every person, irrespective of their gender, their background, their social status, whatever it is. It's very important that we have the right laws, the right instruments, the right policies for everyone to access water. The other question that we have is that do I have an example on how the Uganda Human Rights Commission has been monitoring the right to water and sanitation in Uganda? Yes. The Uganda Human Rights Commission has been monitoring the right to access to water in Uganda. And last year, we monitored issues of access to water in Uganda, and we looked at the whole country. And here we looked at the laws and policies within the country. We looked at issues of availability of water. How available is it? Issues of access to water, issues of distances that people have to take to get to the water sources. We looked at the quality of water in the country and in which places. And we also looked at issues of the cost of water. Now, our findings were that for many persons, particularly the disadvantaged, the marginalized, the poor, we found that access to water is still a big challenge. We found that many people still have to travel long distances to get to water sources, which then is a violation of their water. We also found that the quality of water in many of our rural areas still remains a challenge because they draw water from water streams, from wells, from river banks, and sometimes the water may be contaminated and may not be treated. We also found that particular communities and groups, particularly women, children, persons with disabilities, older persons, have a challenge in accessing water because then they have challenges in walking or accessing water sources. We also found that tapped water that is treated is quite often limited to urban areas, and this remained a challenge. And out of these findings, we made a number of recommendations to government, and we hope that they will be resolved. As a commission, we shall continue pursuing and following up on the implementation of many of our recommendations that we made. And the third question is that did the development of the international human rights law on the human rights to water and sanitation help the Uganda Human Rights Commission work on these aspects, on these specific human rights at the national level? And can I tell them how? Or can I tell you how? The development and the existence of the international legal framework is very critical, because if Uganda has ratified the International Covenant on Economic, Social and Cultural Rights, if Uganda has ratified the Convention on Elimination of all forms of discrimination against women, that's the CEDAW, if Uganda has ratified the Convention of the Rights of the Child, if Uganda has ratified the African Charter on Human and People's Rights, then and all these instruments, regional and international, provide for issues of the right to water, then we're duty-bound as a state to comply and domesticate and implement the provisions of these instruments. And that is why we have the National Water Policy, and that is why as a country we have the Water Act that we as a Commission have been calling on to amend. But the fact that we have instruments, we can use them to push and lobby and seek and lobby and push for ensuring that every person in Uganda can access safe and quality water and in good amounts. Because when we talk about availability, we note that issues of available water and easily accessible water is still a challenge in the country. So as a Commission, we are using the international standards, we are using the international instruments to remind government of its obligation in ensuring that every person should accesses water in good qualities and amounts. And then there's also a question that the African Commission on Human and People's Rights adopted in 2019 the African guidelines on the right to water, which were made public in the summer of 2020. Can I tell you more about the relevance of the guidelines from the regional human rights framework? Now, regionally, it's very important to have this framework. Now, after the adoption of this framework, African states who all came together and said that it was important for us to have water for every person in Africa, provided a guiding document or guidelines on how to ensure that water is accessible, it is available, it is of good quality and good quantity for all persons. So because of that, it guides states on how they should ensure that we have enough water sources in different places. It guides states on how we should ensure that states should ensure that communities have safe drinking water. It guides states on how to ensure that issues of drought are addressed. It guides states to ensure that the people and communities and vulnerable persons are able to access water. So it puts another framework that we use as a national human rights institution to lobby and also talk to the state officials on how best we can communities can access water and what strategies should be put in place to ensure that everyone has affordable, safe water. Now, we as a commission note that even though in urban areas there is tapped water, accessibility and affordability becomes a challenge because many people still cannot afford the high cost of water, which affects their right to an adequate standard of living. And finally, there's a question of why it's important for CSOs to engage in the UPR process. And it's important for us to remember that CSOs are a watchdog of the state. Even though the Human Rights Commission is available to write alternative reports and to also advise the government, it's important for CSOs to write independent alternative report on the human rights situation. It is very important for the UPR process to be as open and as transparent as possible, so that in the event that the state has forgotten or concealed deliberately an issue, the civil society organizations can come out to highlight some of these issues. Now, through the UPR process, they review the previous recommendations, and sometimes states do not comply or respond to these recommendations. So this is where the CSOs also make another assessment on the performance of the state. So it's important that we have different levels of engagement, different levels of responses on particular thematic areas. If it is about access to water, if it's about economic, social, and cultural rights, CSOs play a critical role for them to unearth anything that could have been concealed by the state. CSOs also play a critical role in evaluating and holding states accountable in the UPR process. CSOs also very important that after the recommendations are made, they monitor states' compliance with these recommendations. They monitor states' implementation of these recommendations. And that is why they also play a critical role in the reporting processes, because they make the process more transparent, and they bring out the other side of the picture that the state may not have highlighted. I thank you so much for listening to me. Have a good day.
Now that we heard about the role of the Uganda Human Rights Commission, let us finally look at the role of the United Nations Special Rapporteur on the human rights to safe drinking water and sanitation. The mandate of the Special Rapporteur was established by the Human Rights Council in 2008 as the independent expert on the issues related to these rights. As Special Rapporteur, the mandate holder conducts thematic research, undertakes country missions, collects good practices, and works with development practitioners on the implementation of the rights to water and sanitation. The rapporteurs played an important role in clarifying and developing the normative content of the human rights to water and sanitation, as presented in this lecture. The work of the rapporteur can be found online, including his reports or press releases on current issues. In this lecture, we saw how WASH issues are in fact human rights issues. The normative content of the human rights to water and sanitation and the related principles are used to understand the different aspects and dimensions of these rights and the procedural guarantees that are needed for them to be realized. We also looked at how in practice these norms can be found in national frameworks and discussed the role of different actors next to states, such as CSOs and NHRIs. The next lecture will look more in details at the role of international human rights mechanisms and how they monitor human rights, including the rights to water and sanitation.